The debate over the Obama administration's handling of terror suspects is intensifying, as we have been noticing. The whole debate over the Christmas Day bomber, should he have been read his rights? Joining us now, Democratic Senator Specter, a member of the Judiciary Committee, a former Philadelphia DA, and former chair of the Intelligence Committee. Senator Specter, thank you. The reason I wanted to talk to you today was because you're a relatively independent, even a new Democrat. You have experience as a prosecutor, and you always speak, really speak straightforward on these subjects. I want to hear what you have to say about this whole crazy debate over, should he have been read his rights? Should he have not been read his rights? We're told there are precedents. What do you, as a former prosecutor, say?
I do not believe he should have been read his rights. I think the most important thing is to find what information he has in order to prevent future terrorist attacks. After the questioning is finished, then the Attorney General can make a decision whether to try him in a civil court or in a military commission. Whatever statements he makes would be inadmissible in a civil court if they are admissions or confessions, but he could still be tried before a military commission. If the Attorney General thinks he can prove his case in a civil court without using the admissions or confessions, then I think that is preferable if he can make his case there. I think that shows the world the quality of our judicial system and how fair it is. But the most important thing is to get whatever information he has to prevent future terrorist attacks. More important than his conviction.
Well, you're basically saying that when John Brennan briefed the Republican leaders, Republican and Democratic leaders, on Christmas night and told them that he was being held in FBI custody, that they should not have automatically assumed that he was being Mirandizing, as the White House is suggesting, number one. And then number two, he did not have to be Mirandized within 50 minutes, as he was then turned over for hospital treatment, as the White House has explained.
Well, he does not have to be given his Miranda warnings. The consequence of not giving his Miranda warnings is that if he makes an admission or a confession, you can't introduce it into evidence in a trial, which is in a regular Article III court.
But you can act on the intelligence that you're getting.
You act on the intelligence.
Right.
Then you make a decision as to whether you have enough evidence without the admissions or confessions. Listen, you could convict that guy without anything he said by way of an admission or a confession. So you could still try him in an Article III civil court. And if the Attorney General makes that decision, that's the Attorney General's decision. Now, it's a little different issue as to whether the FBI automatically gives Miranda warnings. I don't think they should. If that is their practice, I think they ought to rethink it when they have a terrorist, because information that the terrorist would give is more important than the conviction, and you can still get the conviction in a military commission. And again, Andrea, you had that guy dead to rights. No matter what he said, you don't have to use it, but you could convict him.